Well, good morning, folks. It's 10 o'clock Eastern Time. Welcome to another edition of Friday Morning Live. Hope you all are safe and sound in either in your office setting or your home office, which we know most are working remotely. So be safe out there if you are out and about a little bit. But today's topic is human resources and COVID-19. Still getting a lot of questions, and I know many agencies are having people come in or doing webinars with their staff about some of these things. And so we thought we'd bring a special guest in today, and we'll bring him on in a minute. But my name's Dave Newell, Director of Education and Workforce here at FAIA, and so welcome aboard again for another edition. Before we get started, let's go. We do it every Friday now. Just stand up and stretch and take a deep breath and relax a little bit and enjoy the ride. So Emily Bond got us a couple new characters this week, Brian. So thanks, Emily. So let's talk about a little thing each week. We just try to engage the audience. So certainly answer these questions in the question pane. How often do you get on a virtual call with your team, either with your sales team or your administrative team or your management team? Just how often you're doing those meetings. Just want to let you know that here with FAIA, most of us are getting on staff meetings or department meetings about once a week. Just checking in. Most of it's through Zoom. We're using Slack as well as a way to communicate with others in the building, but so just curious on that. Wow, 3 times a week. That's amazing. That's good. Keep that team together. All right. Well, then the next question: would you like the flexibility to work remotely once we get out of the stay-at-home orders? So yeah, start. So I'm sure many of you are inclined to do that. It'll be interesting how this all shakes out. We talk about here, and I've talked to many agents about coming out of this, and several staff members are probably going to continue to work remotely. So we'll see how that all unfolds. So, yeah, one agent said case by case. You're right. I mean, this is kind of a proving ground, Rod, right now. Have you set up a Zoom or FaceTime calls with family members? We've started doing that on the weekends with my family and then my wife's family, just kind of seeing everybody, and, texting is so much and talking is so much. But, as we all get a little bit older, we just want to see each other every once in a while. And so that's interesting. And, yep, people are doing it. So that's good. Have you shared a new recipe with others in the office? Because I think, including myself, and I know Brian's in here with me, we like to cook. And so a lot of times I'll share some stuff with my brother or my sister or somebody that's interested of what I'm cooking. I made some baked ziti just the other day, Brian, and my son is the test. And so I know it must be pretty good because it's about gone, and I made it on Wednesday. So, but yeah, that's good. Barbecue. All right. So, keep that in mind. And these are some of the things that you could also kind of share with in some of these meetings and Zoom meetings, just kind of liven things up a little bit. Just a reminder, the coronavirus industry updates has its own page here on our FAI.com website. So we're keeping everything there. That comes from the big I or comes from the industry to try to keep agents up to date. So just kind of check that periodically. And then the community, which is certainly seen a lot of uptick in views, Brian, and activities. But that's where we're putting a lot of the information. Laura just blogged on something from the Department of Labor. So just keep that in mind as you go throughout your day and your week. Just check that out from time to time and see what updates are there for you to take advantage of. Again, a reminder that we're certainly offering more online resources to take your CE, webinars and webcasts. So check the calendar out each week. There you see the website. There's a full calendar of options for you to do that, and we're adding more each week. David and Jeff Odom are starting to add more content, so just be on the lookout for that. And some of the top questions we're still receiving, Brian, here at FAIA for a handful of us that are dealing with agents on a regular basis. Still wondering if the OIR will come out with some kind of a mandate to starve off cancellation, non-renewals, or delay premium payments. Most have seen companies like the Travelers, Safeco just did it. A lot of the auto carriers are now doing it, where they're doing it on their own. So that's not being mandated by the department, but it's certainly they're doing it on their own, allowing cancellations to be stayed, non-renewals to be put off, and certainly consideration for premium payments. I know a lot of the auto carriers are actually reducing premiums for, based on, nobody's driving. So, yeah. And so, but there is nothing formal. We certainly have had several conversations with the OIR, the commissioner, the CFO about these types of things. But really the goal at this point is hopefully the carriers themselves will be dealing with consumers that find themselves in these situations. I posted something late Friday afternoon about Citizens is now dealing with that. They have come up with a mechanism to delay non-renewals, cancellations, and certainly giving some options for premium payments going forward. So we'll see if that continues to uphold, but it is certainly in the OIR's hands. And before we get the question, how can they do that without OIR approval or oversight? They certainly, if they have the wherewithal or the means, they can certainly do that on an individual basis without a mandate. So the encouragement from the OIR is to do that without a specific mandate. So I understand what you're saying, Trey, is how do you police that? But at this point, since there isn't a mandate, some carriers have decided to do it. NCCI FAQs, Frank Paschal has certainly put a couple of them notices out there in the community. They are looking at that, and specifically about what happens to the payroll when you receive that money from the federal government through the to the payroll PPP monies. So NCCI is certainly looking at that, and I think more information to come. So how that payroll will be treated once you receive it. Is COVID-19 covered under the Workers' Comp Act? The CFO, Petronas, issued a directive about for public servants and those on the front line for COVID-19 to extend benefits to those folks. But individual carriers, I think, are still looking at that of how to deal with it. I talked to a couple people this week on that, and certainly they have no problem with folks that are on the front lines, the healthcare workers, the first responders, people that are dealing with this face-to-face on a daily basis. The problem that they're having trouble trying to figure out of how to handle is those folks that are in the construction field or working for a grocery store or a gas station, and they come down with the virus. Should workers' comp apply to them as well? So you got to be careful of how wide you open that door beyond the first responders. So carriers are looking at that. Certainly there's discussions going on with NCCI and others in the industry. So just keep an eye on that. But that's kind of, just like this whole business interruption discussion, you open that door, how wide does that door get to afford coverage that may not normally be there under normal circumstances for a virus like this? And then we had the good fortune this week to be on a call with the CFO and Greg Thomas, our regulator for agent compliance. And it came up about extending your CE compliance date. many of you know, after a hurricane, a lot of times the department puts out an executive order and allows CE extensions to be out there. This particular time, they have not come out with any order. And part of the reason is there's so many more online options available to people. So they feel that many have that option and can stay compliant and work through that with different resources. Certainly, I mentioned our resources here at FAIA. But if you find yourself in a situation because of this, reach out to the department, call Consumer Services, and they will work with individual agents. So they have had, to date, 18 requests for CE compliance extension, and they've granted all of them. So they'll work individually. There's not going to be some kind of an executive order, but I think at this point, they're willing to work with individual agents to resolve anything to help them overcome some of this, working remotely, working from home, and vice versa. So those are some of the things that we're getting here at FAIA. So want to bring in our special guest, Dustin Paschal, who's an attorney out in Dallas. Some of you may have seen Dustin's presentation that was on ABIN a few weeks ago on this subject matter. This is his specialty, his area of practice. This is what he makes his living doing day to day. He's with a law firm out there in Dallas. He's joining us. Good morning, Dustin. Good morning, Dustin. Let me make sure. Okay, apparently you got muted again. Let's try you again. Oh, just bear with me, folks. I had him. There we go. Dustin, good morning.
Good morning.
All right, there we go. All right, so we'll kick this off, but again, welcome, Dustin, and our audience today. And again, we encourage questions. We'll get to as many as we can during Dustin's presentation. Any of those we can't answer or run out of time, we'll certainly get those answered for you offline. But Dustin, as we kind of lay the groundwork of this conversation today, human resources and COVID-19, there's just so many tentacles to this. So just kind of, give us an overview of what you're seeing in your practice and with your clients as far as helping small business and helping employers and employees better understand what's going on as this virus continues to kind of have us locked down.
Yeah. First of all, thank you for having me. I appreciate the opportunity to speak to this group. In terms of what I'm seeing, unfortunately, a lot of the conversations I'm having with my clients are about how to streamline their current staff to get through what they hope is a brief period of shutdown and or smaller operations. And I use streamline as a generous term, but most of the conversations I'm having are about furloughing employees, laying off employees, reducing compensation. How can they keep the business profitable and afloat so that there's something for employees to come back to, but make the tough decisions regarding which employees will or will not have a job for the short term. So that's a big part of what I'm seeing. But then obviously kind of laying as a layer on top of that is this new Families First Coronavirus Response Act and how the FFCRA comes into play and when they're going to be responsible for paying sick leave to the employees that they retain or expanded family leave for the employees that they retain. And so it's really just the conversations I've been having, which I'm sure many of you have been having, is how do we make this work? How can we incorporate all of this into our current policies, our current procedures, especially in light of a lot of my clients are small business owners. And so how does it work for people that may be profitable, but they're profitable with very thin margins in terms of their expenses, and throwing all these extra requirements in is really throwing them for a loop. So it's a lot of tough decisions, a lot of tough conversations. But from what I've seen, I'll commend employers. Virtually all the employers I speak to are bending over backward and racking their brains to figure out not only how to keep the company open, but how to save the jobs of their employees. I have not yet had a conversation with someone that's just said, all right, I'm going to cut everybody. This has not been a tough decision. Let's move on. That's not the case. So I commend employers for everything they're dealing with in this, shall we say, interesting time that we're in.
Yeah, as we go to the first slide, and you mentioned Families First Coronavirus Response Act, that question up there is, who does it apply to and what are the requirements? So for our purpose today, Dustin, can you kind of give us a good overview of that act?
Sure. So that one has that was kind of I call it the first. I know that Congress passed kind of an initial act, and this I think was more phase 2, but I call it the first one because it was really the first one that kind of affected a wide swath of people. So the gist of it was the FFCRA had 3 aspects to it, essentially: an expansion of the Family Medical Leave Act, and then an emergency paid sick leave portion, and then a third portion that was about unemployment, which for purposes of employers, I don't go into a ton just because that's more related to the state. What I generally tell employers there is it's just a point of counseling for employees. If you have to let someone go, or you are furloughing someone, keeping them on the payroll, but they're working no hours, earning no income, they're still generally eligible for unemployment. It's just kind of a way to tell them, hey, there's money going to be there in the state coffers. So, go file for unemployment, but there's not a lot for employers to know there. So I focus on the kind of the expanded Family Medical Leave Act, and then the Emergency Paid Sick Leave Act. So both of those acts apply to employers that have fewer than 500 employees. That really applies to a huge amount of businesses that maybe weren't otherwise required to provide any kind of paid sick leave, or weren't otherwise subject to the FMLA, previously the Family Medical Leave Act. But so it applies to any employer who's got fewer than 500 employees. It does apply to government employers as well, but there's some differences with some of those. I'm not a government lawyer, so I don't get into those in vast detail. I know they don't get to take advantage of the tax credits that are there and whatnot, but it does apply to them. But essentially what the 2 laws do, and I know we can get into the meat of them as kind of more details as we go through, but the gist of each law is the Emergency Family Medical Leave Expansion Act does exactly what the title says. They expanded the existing FMLA. So they basically provided they provided an additional reason for which employees could take 12 weeks of leave, and they expanded the application of the FMLA to employers. Historically, the FMLA only applied to employers who had 50 or more employees. Now, for this new reason, it obviously applies to any employer that's got fewer than 500 employees. It only applies to employees, though, who have been on the payroll for 30 calendar days. So it's not necessarily every employee if you've got a newly hired employee. And what it does is it adds that 6th reason, that if an employee has to be off of work or is unable to work or telework, is the way they word it, due to the fact that that employee is caring for a child whose school has closed, or whose child care facility childcare is unavailable due to COVID-19, then that employee can be eligible for up to 12 weeks of leave. And they break it down essentially, with the first 2 weeks is unpaid. Employees can opt to utilize accrued PTO during that 2 weeks if they would like. And employers can require employees to use PTO during that first 2 weeks if they prefer, subject to the Emergency Paid Sick Leave Act we'll talk about in a second. But so the 2 weeks is unpaid unless one of those things happens, that the PTO is used. And then the final 10 weeks are paid at a rate of 2/3 of the employee's regular rate. And then it provides a tax credit for employers to take with respect to that 2/3 rate. Now, that's a very broad overview. We'll get into some of that in later slides for the Emergency Family Medical Leave Expansion Act, but that's a broad overview of that one.
Okay. And let's
go ahead.
Let's just, and we'll go through the slides. And certainly, again, that's what Dustin looks like. He is an attorney, practicing attorney in this area. But let's talk about, do the regular FMLA requirements still apply now that this act is in place?
So yes and no. So generally, because this is an expanded act, the FMLA requirements still apply. Those original FMLA eligibility rules, if you were already subject to the FMLA as an employer, if you had 50 or more employees, those still exist. So employees can still take leave for a serious health condition, for the birth or adoption of a child, those reasons that are outlined in the FMLA. And you can still require a certification of a healthcare provider, and kind of all those requirements that existed under the FMLA still exist in this world that we're in now. What's happened is, like I said, they've added this sixth reason, which is care for a child related to school closure or child care unavailability due to COVID-19. And it has kind of its own interpretations and its own requirements. For example, one requirement that's typically under the FMLA that doesn't apply here is job restoration. Under the original FMLA, employers are required to return any employee who was on FMLA leave to the same or equivalent position. Now, that still exists for the existing reasons, but for this sixth reason, this new reason under the expanded act, an employer with fewer than 25 employees does not have to return an employee to their original job if they take leave under this new expanded act, so long as the employer can establish that the job doesn't exist anymore because of economic conditions or related to COVID-19, that the employer attempted to return, made reasonable efforts to return the employee to an equivalent position. And then if an equivalent position wasn't available, the employee or employer basically spent a year trying to stay in contact with the employee to return the employee to an equivalent position to the extent one arose in that year period. So that's kind of a lightening of the requirements under the FMLA for this new reason. But otherwise, all of the FMLA requirements are still in existence. It hasn't taken those away.
Okay. Question came in, Dustin, and I know this speaks to employers with 500 or fewer employees, but specifically the question is, does an employer with less than 50 employees have to comply with reason number 5 of the 6 qualifying reasons? Is caring for his or her child whose school or place of care is closed or child care provider is unavailable due to COVID-19 related reasons?
Right. And so what we're talking about there, and I hadn't hit on the Emergency Paid Sick Leave Act yet.
Okay.
We can hit on that in a few minutes. But yeah, that's the one with the 6 reasons.
Okay.
Reason number 5 is a crossover.
Okay.
That's also the only reason available for the new expanded FMLA. So it's in both of these new acts. It's that care for a child whose school or child care facility or child care is unavailable. And the Department of Labor regulations do allow an employer with fewer than 50 employees to be exempt from those requirements. So it's essentially to be exempt from the expanded FMLA altogether, and then be exempt from reason number 5 under the Emergency Paid Sick Leave Act. Now, a point of caution that I would make on that is the way that the regulations are worded are such that it's not a wholesale exemption. So like an employer can't just come in and say, I'm fewer than 50 employees, everyone's exempt from the expanded FMLA and reason number 5 on the Emergency Paid Sick Leave. No one has to worry about that. That's not entirely true. The way the regulations are worded, you're really, as an employer, supposed to look at it on an as-employee basis. And so it could be that you have, if you're an employer under 50, you've got maybe 20 employees that could be exempt from the law, but the remaining 30 are not exempt from the law. You're really supposed to look at it on an employee-by-employee basis. And the reason they say that is because they provide reasons. Essentially, they say, you're exempt if you can show that compliance is going to jeopardize your business. And the way you can show that is to either show that the expenses in providing the leave will outweigh your revenue such that you're essentially not able to operate.
Right.
Or number 2, that the employee is essentially so critical to the operation of the business, their responsibilities, their duties, their skills, their know-how, whatever it may be, but they are so critical that allowing them to take the leave would jeopardize the business. Or the third reason is, if the employee leaves, I don't have another employee who's willing, able, and qualified to perform that employee's job, so they can't leave. The example there would be like, let's say you've got someone, only have one payroll person and no one else in your business does payroll. Well, now that person's become like kind of a critical role. If they leave, you have no one else able to do the payroll, you could claim the exemption for them. But that's why I say it's on an employee-by-employee basis, because there may be employees that want leave, if you're under 50 employees, that giving them leave would not implicate one of those 3 things that I outlined there. And in that instance, you would still need to give them leave. So you can't just make a wholesale, I'm under 50, I'm good to go. You really should look at it case by case and really examine it according to those standards.
Well, and for what I hear, Dustin, and certainly the agents on the line, this is a area expertise. You need to consult a human resources lawyer, a consultant that does this on a day-to-day basis to make sure you don't go outside, as you say, outside the governing rules of that particular issue, with the expanded rights. So,
yeah, absolutely. It's critical to do that because, essentially, the Department of Labor could just come in and say you violated it and institute all sorts of damages and penalties against you.
Well, again, Dustin, we talk about the new law requires an additional 12 weeks of leave above which the FMLA already provides. Kind of walk us through what that requirement is or what the new law does to expand an additional 12 weeks.
Yeah, and so there was some question there when the law initially came out of whether it was an additional 12 weeks or not, and the Department of Labor has cleared that up with their regulations. It's not an additional 12 weeks. All it does is if you look at, if you're kind of a law nerd and you want to look at the law, basically the existing FMLA says employers must provide 12 weeks of leave for the following reasons, and it lists 5 reasons. All the new law has done is add a 6th reason. And so because of that, the Department of Labor clarified this new law, this expanded FMLA for the care of a child, is not an additional 12 weeks above and beyond existing FMLA. It's just another reason to use those 12 weeks. And so to put it in kind of a practical example, this whole debate really only matters for people who were already subject to the FMLA, because if you weren't subject to the FMLA, this would never become an issue for you. But for those that were already subject to the FMLA and having to comply with it, let's use the example of you got to provide 12 weeks in a calendar year. Let's use the example or in a 12-month period. It can be calendar or rolling. But let's use the example of you use a calendar year, and let's say in January, one of your employees had surgery and took 4 weeks of FMLA leave to recover from that surgery. Well, what this new law says then is they don't get 12 weeks now for the care of a child whose school or childcare is unavailable. They've already used 4 weeks of FMLA leave, so they only have 8 weeks left. So they can only use 8 weeks of leave for the care of a child whose school is closed or childcare is unavailable. And kind of let's use it as a point of counseling. Let's say you have an employee who, had surgery at the beginning of the year and was off a couple of weeks to recover. Let's say their spouse is pregnant and the employee wants to take time off at the end of the year under the FMLA when the baby's born. Well, you need to tell that employee then, hey, just keep in mind, you've already used 2 weeks. You only have 10 weeks left. So if your wife's going to have another child later in the year and you want time off for that, you need to preserve that time. If you utilize it all now to care for your existing child whose child care is unavailable, you may not have that time. So it's a 12-week total for any FMLA reason. This new law did not provide an additional 12 weeks.
Yeah, I think that's where a lot of the confusion lied with employers and members that we were getting questions about. I think everybody, like you say, Dustin, had originally thought they were getting an additional 12 weeks with the new law. So, all right, well, let's go to the next slide and talk about anything else that you think these folks on the call today need to know as employers about the new law and the aspects of it, just to keep in mind as they go forward as we continue to stay, in stay-at-home modes in most areas of the country, especially here in Florida.
Sure. So let's talk about just real quick, because we haven't hit on it yet, the other aspect of the FFCRA, which was the emergency paid sick leave. We talked about the Emergency Family Medical Leave Expansion Act, but let's talk about the emergency paid sick leave, which, just like the EFMLEA, applies to employers with fewer than 500 employees. What it does is provides 2 weeks of paid sick leave to any employees. That 30-day working requirement doesn't exist for this portion, but it requires 2 weeks of paid sick leave for any employee who's unable to work or telework due to one of 6 reasons. And those reasons are either 1, the employee is subject to a federal, state, or local order to quarantine or isolate. Number 2, the employee is advised by a healthcare provider to self-quarantine. Number 3, the employee has COVID-19 symptoms and is seeking a diagnosis. Number 4, the employee is caring for an individual to which either the government order of quarantine or the healthcare advice to quarantine applies. Number 5 is that crossover with the EFMLEA, the caring for a child whose school or child care is unavailable due to COVID-19. And then there's kind of a 6th catch-all reason that I find it somewhat comical that was included, because there's been absolutely no guidance or explanation from anyone within the Department of Labor of what that reason really means. And so it's kind of become not a reason. So really there are 6, but really the only reasons that people are utilizing are 5 reasons. And so the Emergency Paid Sick Leave Act provides, again, 2 weeks of sick pay for those reasons. The way it does it is those first 3 reasons, the employee, himself or herself, is subject to a government order, the employee is advised by a healthcare provider, or the employee has symptoms and is seeking a diagnosis. For those 3 reasons, the employee is eligible to be paid at his or her regular rate for those 2 weeks, capped at $511 a day. That equates to like $133,000 annually. So basically, any employee at $133K or less can get their full pay for that 2 weeks. People making more than that obviously would not get their full pay because it would be capped out. And then the second 3 reasons are also paid, but only paid at 2/3 of the employee's regular rate, capped at $200 per day. And where you see here some crossover is that 5th reason under this emergency paid sick leave, the caring for a child whose school or child care facility is closed. Employees can use that to run concurrently with that EFMLA that we already talked about, such that the full 12 weeks under the EFMLEA is paid rather than just the final 10 weeks. So they can run them concurrently to guarantee that they get pay there. But keep in mind, they only get 12 weeks for care of a child whose school is closed. So as an example, let's say an employee wants to preserve their paid sick leave in case they get sick or something. They can do that and take the full 12 weeks under the EFMLEA, but that first 2 weeks of the EFMLEA would be unpaid unless they use PTO. But if they use the full 12 weeks under the EFMLEA and don't concurrently run the paid sick leave, then they can't later use 2 weeks of paid sick leave for that 5th reason. It can only be used for one of the other reasons. You're not going to get more than 12 weeks for care of a child. But that's kind of the Emergency Paid Sick Leave Act portion of the FFCRA. And I'll hold so we can continue to go through the questions, but to the extent we have time or to the extent there's some questions or people prefer it, I can go into some detail on how those reasons under the Emergency Paid Sick Leave Act have been interpreted and defined by the Department of Labor.
Yeah, one question, Dustin, deals with, when this came out, our CFO sent staff the flyer that says employee rights.
Sure.
Are there any rules and regs surrounding about notification to employees from employers about these rights and having them displayed or something electronic? I'm just curious, are there any guidelines to what you need to do with that document?
Yeah, so talking about notice, I kind of lump those in together, like notice and record keeping requirements.
Yep.
Yeah, the Department of Labor does have a model notice that's on the Department of Labor website. They actually have one in both English and Spanish, although currently there is no requirement to post the Spanish one. Usually you see in kind of the world of employment posters, they say if your workforce is primarily Spanish speaking, you're required to post a Spanish version. They have not said that for this law for some reason, but they did provide a Spanish one. So I would say if your employees are primarily Spanish speaking, post the Spanish one. But all they've said is that you need to post that model notice in a conspicuous place at your workplace, and it must be posted as of April 1st. Now, they've relaxed it somewhat, obviously, which makes sense since many people are working remote. You can comply with the requirements to post in a conspicuous place by either emailing a copy of the notice to all of your employees, direct mailing it to all of your employees, or if you have an internal or external website that employees access, you can post it on that. And any of those things will satisfy the compliance to post in a conspicuous place at your workplace. So you just have to post a notice. And that's really the only requirement regarding notice. With respect to record keeping, just something to keep in mind, any records that you have related to any of this leave, and that would be like if people take the leave, they need to provide you justification for why they need it. They provide you doctor's notes. They provide you whatever they may provide you. All of those records related to anything under this law must be maintained for 4 years.
Interesting. Okay. Question came in. If possible, please clarify. Dustin, you said that the employee claiming reason number 5 is not entitled to pay for the first 2 weeks. Can you just kind of clarify that?
Yeah, so it's kind of this weird crossover between the emergency paid sick leave, which provides 2 weeks of paid sick leave, And one of the reasons is care for a child whose school or child care is unavailable. That reason number 5. But then there's also the Emergency Family Medical Leave Expansion Act, which the whole point of that one is care for a child. And so you have to look at them in conjunction, but it's this weird, what I'll call a kind of a 2-step process. So under the EFMLEA, the family leave one, the employee can get 12 weeks, and the first 2 weeks is unpaid. Now, what the employee can do is they have some options. For that first 2 weeks, they can either utilize existing PTO that they have if they want to have the 2 weeks paid that way, or they can concurrently run reason number 5 from the emergency paid sick leave and get paid the emergency paid sick leave pay for that 2 weeks. Now, the difference is if they utilize PTO to run concurrently during that first 2 weeks that's unpaid, they're going to get their full rate of pay because it's PTO.
Right.
If they run that first 2 weeks concurrently with the emergency paid sick leave, they only get it at 2/3 of their rate because that's what the emergency paid sick leave law requires. The reason I said it's a 2-step process is because the 2 parts of the law have different rules regarding what an employer can and cannot do. Under the Emergency Family Medical Leave Expansion Act, for that first 2 weeks that's unpaid, the employee can opt to use PTO, or the employer can mandate that the employee use PTO. But under the emergency paid sick leave portion of the law says that an employee has the right to use the sick leave before PTO, and an employer cannot require the employee to use PTO first. So when you look at them in conjunction, if someone comes to you as an employee and says, look, I want to take time off because I have to care, I can't work because I've got to care for my child whose school is closed. I want the full 12 weeks. Then you have to say, okay, for that first 2 weeks, it's unpaid. Do you want to run that concurrently with the emergency paid sick leave? And if the employee says yes, discussion done, you just do 12 weeks at 2/3 the rate. If the employee says, no, I do not want to use the paid sick leave for that first 2 weeks, now step 2 is to say, okay, would you like to use your PTO for that first 2 weeks? And if they say no, then you as the employer have the right to say, I'm going to require you to use your PTO. But you can't require them to use the PTO before you give them the opportunity to decide whether or not they want to run the emergency paid sick leave concurrently first. So it's kind of a convoluted little 2-step process because the laws have 2 different requirements, but that's how the process would play out.
Okay. All right. And we'll just keep moving, and again, we'll run through these pretty quickly. Can employers send their employees home that they suspect might have the virus? What's the rules and regs on that, Dustin?
Yes. Yeah. Short answer, an employer absolutely can send their employee home if they suspect they might have the virus. That's not really going to implicate the current the new laws, because if the employee doesn't have symptoms, then there would be no category within which the employee falls for paid sick leave. So it would kind of default to, if they had PTO, you might have to pay them their PTO. But employers absolutely have the right to send employees home that they suspect might have the virus.
All right. What about employers send, the next one. Can employers prohibit employees from coming into work that have recently traveled? I know this was a big one at the beginning. Most of us are not traveling now, but certainly if you suspect this was occurring, do you have those rights?
Yeah, you absolutely do. And yeah, you're right. It was a bigger issue at the beginning. People aren't traveling as much, but I will say we're starting to see it creep up a little bit more, because as people are in these shelter in place orders, they're kind of going stir crazy. And so people are saying, well, I know I can't get on a plane, but I can hop in my car with my family and we can do a mini vacation that's within driving distance and go rent a cabin or something. And a lot of employers are saying, well, I'm still bothered by that because you're encountering gas stations and people as you drive, and who knows who you encountered when you were checking into the cabin. And I'm not comfortable with you being in the office because I don't know where all you've been. So employers absolutely can prohibit employees from coming into the office who've recently traveled, or employers can say, I'll let you come in once I make sure you're symptom free and whatever other traps I want to run through to make sure that you're okay to be in the office.
Okay. What about asking employees? Again, we're working remotely. Can you, as an employer, can you ask employees if they're exhibiting any symptoms?
Yeah, and that comes up more for people who are still coming into the office. Let's say if you're subject to a shelter-in-place order, but you're an essential business, so you've got employees still coming in.
Yep.
But you can ask either way, whether they are remote working or coming in. Historically, you would not be able to ask those kinds of questions as an employer because that's considered diving into an employee's medical information, and that's prohibited by the Americans with Disabilities Act. But under the current pandemic situation, those rules are essentially suspended. And so during a pandemic situation, employers can ask employees if they are experiencing any symptoms of the virus.
Okay. Can employers take an employee's temperature? Interesting.
Yeah, absolutely. Again, this is another one of those where in a normal situation, no, because it would be considered a medical exam prohibited by the Americans with Disabilities Act. But in a pandemic situation, that is allowed. Now, a note of caution is not everyone that has the virus has a fever, so it's not a fail-safe. But many of the people that have the virus have a fever, and so you can take a temperature. And again, this happens more often where I'm seeing this a lot. Like I've got clients who are construction companies, and their employees often live paycheck to paycheck. So their employees do not want to stop working. They want to keep working. And they're essential businesses, so they're allowed to. And so what some of these people are doing is buying those, I call them fancy, maybe they're more normal these days, but those fancy thermometers that you can do from a distance where you just point it at somebody and it'll kind of give you their temperature. And they're basically just assigning an employee to be at the opening, the gate to the construction site. And as employees arrive, they just kind of zap them with the thermometer and check their temperature. And if they've got no temperature, they're allowed in. If they have a temperature, they're sent home. So employers absolutely can do that.
All right. Let me make sure I don't know why bear with me. There we go. Can employees require employees to utilize PTO if they are not in the office or remote work is not available?
Yes, if. And so the if is as long as they're not eligible under this new law. And
Okay.
So, again, that would apply to, let's say there's someone that either they've traveled and so you're not comfortable with them being in the office, but they're not exhibiting any symptoms, so they don't fall into one of the protected area or one of the eligible areas under the new law. Or let's say you've got an employee who says, I'm just not comfortable coming into the office because I'm afraid I might get it if I get out of the house, but they're not otherwise exhibiting symptoms or fall into one of the categories under the new law. In those kinds of instances, if remote work is not available, you can absolutely tell that employee, I'm going to require you to use PTO in order to be off. Okay.
All right. Can employers require employees to provide a doctor's note? And I know in many instances that's required in the normal, manual, the employee manual. What about in this instance? Can you require a doctor's note to return to work?
Yeah, you can. And it's kind of this weird dance where employers generally are required under the law to provide what's called a generally safe workplace. And so a lot of people are saying employers kind of have a duty to require a doctor's note if someone was out related to the virus, just to make sure that they're not infectious and infecting coworkers. But then on the flip side, you're hearing reports that doctors' offices are overloaded and don't have time to provide doctor's notes to people who are healthy because that's not their focus. So it's a weird dance going on. I don't think I am in the group of people that believe it's the duty of the employer to get a doctor's note. But I certainly can answer with certainty that employers are legally able to require such a note if they'd like to.
Okay. This is a good one. Can employees refuse to come to work? I mean, what's their rights?
Yeah, so absolutely. There's two different laws here. Well, I say absolutely. Absolutely meaning there's some laws that give them that right, but because this is all new, there's been no cases or litigation to kind of determine if those laws apply. But I mentioned OSHA. It exists. It applies to every employer. And under OSHA is the right for employees to refuse to come to work if they believe they are in what's called imminent danger. Now, we don't know if this pandemic would be classified as imminent danger under OSHA, but there's enough of a question there that I've been telling my clients, do not take any adverse action against employees who refuse to come to work, because they very well might be protected under OSHA. The other law that applies would be the National Labor Relations Act. And a lot of people think that they're not subject to that because they don't have unions, but the National Labor Relations Act applies to all employers, whether you have unions or not. And it provides employees the right to engage in what they call protected concerted activity, which is activity to basically challenge their workplace conditions. Usually it's used to challenge wages and things like that, but they certainly could use it to challenge the safety of the workplace if they feel the workplace is unsafe. So there's enough of a risk having two different laws that provide some protection that I, as an employer, would allow my employees, if they refuse to come to work, I would allow them to stay home. The only question is, if they're not eligible under the new law, then I would say, sure, you can stay home, but I'm not going to pay you. So that's your choice.
Right. All right. What about, I talked a little bit about this on the onset about what the CFO in Florida has done for first responders, but, can an employee file workers' comp if he or she gets the virus?
Yeah, I mean, I was glad you mentioned that, because that's the guidance I'm seeing as well, which is I've not seen any states come out and say per se, no, employees cannot file for workers' comp if they get the virus. But what I'm seeing is it will be difficult for employees, for the most part, to establish a claim, because generally to establish a workers' comp claim, you have to show that you got the virus as a result of your employment. It's so widespread at this point, it's going to be difficult, and there's no way to track where you got it. It will be difficult for employees to establish that they got the virus as a result of their employment. Now, the exception is what you mentioned at the outset. Kind of these first responders and healthcare providers, it's going to be pretty easy for them because they're dealing with people who have the virus. So they probably will not have an issue establishing a workers' comp. And the same might go for restaurant employees. But day-to-day employees, like if you just have an office and you're an essential business and you're open, it's going to be very, very difficult for an employee to establish they got the virus by coming to the office, because how do we know you didn't get it interacting with someone at a gas station, or picking up to-go food, or interacting with someone in your family who got it from some other issue? We can't track it. And so for non-healthcare people, non-emergency responders, they're going to be eligible to file, but they're likely going to fail in establishing the claim. Right.
What kind of actions should employers make sure they are avoiding? I think you mentioned adverse, taking adverse action against an employee. What other things should employers that are on this call today consider avoiding or not doing while we're under this pandemic?
Yeah, we talked about if an employer refuses to come to work. Another one, a very basic one that, I'm not seeing widespread, but you see reports in the news about it. Make sure you're avoiding any kind of discrimination based on national origin or race. You don't want to be targeting employees of Asian descent, because obviously that's going to implicate anti-discrimination laws under Title VII at the federal level. So make sure you're avoiding that. But even, any decision that's going to be based on a protected category. I saw a question today from someone who said, when all this is over, when the shelter-in-place orders are released, how are you going to return your employees to work? I've seen people say, I'm going to return my young employees first because they're not as susceptible to the virus, and then I'll return the older employees later. Well, that's a dangerous proposition, because now you're kind of making a determination based on age, and you might be implicating some age discrimination concerns. So employers should avoid making any decisions that are going to be based on any kind of protected category. And the other thing to keep in mind is, while the Americans with Disabilities Act likely doesn't come into play a whole lot here from protecting people. Oh, I see. It just pops up with a question here. Yeah. It doesn't really come into play because they haven't said that the virus would qualify as a disability. It's too transitory and minor. So it's unlikely to be a disability, and it's unlikely to even satisfy a regarded as discrimination claim because it's so transitory and minor. But there's potential, at least there's at least a small risk that if you believe someone has the virus and treat them negatively, that might be considered a regarded as discrimination claim that implicates the ADA. I think that's a low risk, but it at least exists. So if you believe someone has the virus, or they do, it's okay to send them home and stuff like we talked about previously, but don't take adverse action against that employee.
Okay. Next up, and certainly because insurance agents and insurance companies have been deemed essential, so a lot of our members are open. They may be working remotely, and they may not allow public to come in and out of the office, but many of them insure businesses that have had to shut down completely. Is there anything about which it should be aware of? What should they could advise some of their clients that are actually had to shut down completely, like restaurants and bars and things like that?
Yeah, and I've got some restaurant clients that are in that situation. So, the key to know there is if you're shut down completely, you're not going to be subject as an employer to this new law. So even if you retain your employees, so some people are shutting their operations down, but they're not laying off their employees. They're more furloughing those employees. So they're basically maintaining them on the payroll so that those employees can still get their health care coverage, but they're just not giving them any hours or any compensation because there's no work to do because they're shut down. There was some fear that people said, well, if I keep them on the payroll, they might be eligible for these new paid leaves under the law. And the Department of Labor has made it clear that if you are shut down, even if you retain the employees on your payroll, if there's no work for those employees to do, they're not eligible for this paid leave. So for employers that were scared about that and were thinking about actually laying off and separating employees to avoid application of the law, they don't need to do that if there's truly no work available for those employees. Okay.
And what about this, Dustin? What is your advice for employers on what they should be doing during this virus outbreak?
Yeah, I mean, it's funny to say as a lawyer, but I've been telling my clients, just have some heart and have some understanding. And to the extent that remote work is available, offer it. Even if understand that you're going to have to provide some flexibility. And so your employees may not be working 8-hour days while they're working remote for you. They may be working a 4-hour day or a 6-hour day, or they may go 2 or 3 days of no work and then work 4 or 5 days in a row. Or, give them some flexibility. As long as they're getting their tasks done, understand that that's all that matters at the end of the day. So provide some flexibility when it comes to the remote work environments. And then if you are an essential business and your office is open and you've got employees coming in, make sure that you're providing that safe workplace. So OSHA has provided some guidance. It's on the Department of Labor website. I would encourage you to go look at that. It outlines what you should be doing to protect your employees. So if you've got to be in operation, make sure you have a cleaning crew that's coming in on the regular and doing top to bottom cleaning. Make sure you're providing hand sanitizer for your employees. Make sure you're, to the extent you're able, keeping your employees that 6 feet or more distance between them. Take those steps to provide masks to your employees, provide gloves to the extent it's applicable. I know there's some debate on whether that's really helping or not, or spreading because of the way people use gloves and don't really often pay attention to how they're using them. But provide those tools and those mechanisms such that you can make the argument, even though I'm having you come into the office, this is a safe environment, and I am doing everything in my power to prevent you from getting the virus by coming into the office.
Okay. And then before we get some parting shots, what about those situations that want to stay open but can't provide remote work for those staff members?
Yeah, and that's what you have to forgive me. I'm in my office and the clock's dinging. I hope you can still hear me over that. The joys of working from home. That goes to my point of be flexible. If you've got a call and somebody's dog barks, the clock dings. No, I mean, it's that same thing. Like if you've got to stay open and you don't have that remote work available, it's just that thing of provide some flexibility, make sure the facility is clean and you're providing a safe environment there, but provide some flexibility to the employees if they need to come in a little bit later or leave a little bit earlier because they've got childcare issues, or they need to maybe just take a day off in the middle because they've got to handle they're working with their spouse to handle their kid. It's just having that flexibility because that's going to go a long way. I always, in my practice, have noticed employees that feel their employers have taken steps to help them are much less likely to file claims against their employers down the road.
Right. Well, Dustin, folks, you see Dustin's picture up there. You see his contact information. Certainly, we appreciate his time today on a subject that kind of just, Dustin, you'll agree. I mean, it changes quite a bit, almost weekly, of
Yes.
different questions, different nuances to the law, but questions that employees and employers are facing each day on this. So, if you want to reach out to Dustin, there's his email address. Certainly do so. Give him a call. You can retain his services and walk through some of this, because just by sitting here today, and certainly have some great comments, Dustin, about a great webinar providing this information, but more so having a resource like you. Remind everybody that Dustin has done a full-scale webcast on ABIN. So you can certainly go online and look at that and see Dustin talk about some of these issues as well during that webcast. So, again, thank you, Dustin. Be safe. Take care of the family. And I know the law practice doesn't stop. You're getting emails and calls and text messages from clients. So thank you so much. Have a great weekend, and we appreciate your time today.
Yeah, you bet. Thank you for having me.
Okay. All right, folks, just want to remind everybody that we have some upcoming sessions next week. Nate Ginter with one of our FMS providers, Vine IT, will help us better understand securing our data while working remotely. And then the following week, Frank Paschal will talk about the question about the workers' comp that we discussed a little bit today, but certainly some of the nuances of not only for first responders, but those working remotely. And then we'll have shows beyond that. But want to thank everybody for tuning in today. Be safe out there. If you have any questions or concerns, certainly send us a note here at FAIA, dnewell@fai.com, or most of you have the addresses for many of us. So, but reach out to us. We're here to help. We're here to provide information, and hopefully this did that today during today's Friday Morning Live. Have a great weekend, and we'll talk to you soon.